Good morning, everyone. Today I will be discussing the legal circumstances surrounding a dispute between a coal mine owner and the police authorities during a mine strike. My analysis will be based primarily on Australian contract law, supported by relevant case law and statute law references. Let me begin with a brief overview of the facts of the case. During a miners' strike, the coal mine owner faced a significant threat. Without maintenance by the safety men, the mine would have floated, causing catastrophic damage. Recognizing the damage, the owner requested police protection to safeguard the maintenance workers. Initially, the police authorities believed that periodic mobile patrols would suffer to prevent any trouble. However, after negotiations between the parties, it was agreed that permanent police force would be stationed at the mine. In return, the mine owner would pay for their services at specified rates. Yet, once the strike concluded, the owner refused to honor the agreement and declined to pay for the police services rendered. This brings us to the central legal issues. First, whether a legally binding contract existed between the coal mine owner and the police authorities. Secondly, whether the owner refusal to pay
PPT 没切，
一定要签吗？
对呀、你都读到下一页了。
哦，这样的。
对呀、
PPT 它会录进去吗？
那肯定要录啊。
哦，我以为就不用录，那重新来。
你看人家告诉你 slide 1了，
哦，
然后你 slide 2了，你就得切到下一页了。
那我重新读吧。
这不 facts of the case 吗？这是 facts of the case。
啊，
对，
那重新录。
记得切。
啊，它这个整个屏幕录进去了。
对呀、对呀、笑死我了你！
重新录。
总要等录。
Right.好了，slides 开始啦。
开始了。
Good morning, everyone. Today I will be discussing the legal circumstances surrounding a dispute between a coal mine owner and the police authorities during a miners' strike. My analysis will be based primarily on Australian contract law, supported by the relevant case law and statute law references. Let me begin with the brief overview of the facts of the case. During a miners' strike, the coal mine owner faced a significant threat. Without maintenance by the safety men, the mine would have floated, causing catastrophic damage. Recognizing this damage, the owner requested police protection to safeguard the maintenance workers. Initially, the police authorities believed that periodic mobile patrols would service to prevent any trouble. However, after negotiation between the parties, it was agreed that a permanent police force would be stationed at the mine. In return, the mine owner would pay for their services at specified rates. Yet, once the strike concluded, the owner refused to honor the agreement and declined to pay for the police services rendered. This brings us to the central legal issues. First, whether a legal binding contract existed between the coal mine owner and the police authorities. Second, whether the owner refusal to pay constitution as a branch that contract, and if so, what remedies are available. Now let us move to the applicable area of law. This case is principally governed by Australian contract law. In simple terms, a contract is a legally enforceable agreement between two or more parties. For a contract to exist, there are several essential elements that must be certified. These include an offer and acceptance, consideration, an intention to create legal relations, and certainty and completeness of terms. These principles are deeply rooted in the common law, but they are also supported by key statutory frameworks, in particular the Competition and Consumer Act at the Commonwealth level, especially Schedule 2, which we know as the Australian Consumer Law, provides important support for contractual obligations. Additionally, the Civil Liability Act addresses obligations and potential liabilities where contractual and duty of case issues arise. We can also draw a guidance from several important cases. First, Khalil the carbolic smoke ball code, which clarified the principles of offer and acceptance. Secondly, Australian Woolen Mills Pry Limited Commonwealth, which confirmed the end for considerations in a binding contract. Third, SE Petroleum Co. Limited Commissioners of Customers and Exists, which emphasized the permission of an intention to create legal relations in commercial agreements. And finally, Secured Income Real Estate Australia Limited, the Streeton Martins Investments Party Limited, which confirmed that non-performance without a law exists constitution a branch of contract. In summary, both common law cases and key pieces of legislation, namely the Competition and Consumer Act and the Civil Liability Act, particularly Section 5B, together form the legal foundation for understanding and resolving this dispute. Let me now walk you through the key elements of a valid contract and how they apply to this case. First, there must be a clear offer. In this case, the coal mine owner made an express offer when the requested ongoing police protection in exchange for payment. This meets the standard of an offer, as defined in Carbolic Smoke Ball Code 1893 1 QB 256, where an offer is an expression of willingness to be bound on certain terms. Second, there must be acceptance. The police authorities agree to provide a resident force at the mine under specific conditions, thereby accepting the owner's offer. Acceptance must mirror the offer exactly, and these requirements was satisfied here. Third, consideration must exist. Consideration refers to something of value given in exchange for a promise, as confirmed in Dunlop Polymanic Tri-Co. Limited, Selfridge Co. Limited. In this case, the police services constituted the consideration provided to the owner, and the owner promised to pay the specified rates was the reciprocal consideration. Fourth, there must be intention to create legal relations. In commercial contexts, it is generally presumed that parties intend to create legally enforced obligations as affirmed in SO Petroleum Co. Limited Commissions of Consumer and Exists. Finally, the agreement must have certainty and completeness. The terms were clear. The nature of the service, ongoing police protection, and the payment obligations, specified rates were fully articulated, certifying the need for certainty. Having established that all elements of a valid contract are present, we now turn to the issues of breach. A breach of contract occurs when one party fails to perform their contractual obligations without a lawful excuse. In this case, the court might honor the refusal to pay for the police services that were agreed upon, delivered, and relied upon during a crucial period clearly constitutes a breach. This principle is strongly reinforced by High Court decisions in secondary income real estate Australia, Late Street Malians Investment Party Limited, where it was held that failure to fulfill a fundamental contractual obligation, particularly one that goes to the heart of the contract, results in a breach. In that case, the court emphasized that parties must perform their promises unless excused by law, and any unjustified refusal undermines the contract core foundation. Thus, the core my honest conduct amounts not merely to technical breach but repudiation of the agreement, demonstration of unwillingness or inability to perform essential terms, and entitling the incorrect party, in these instances the police authorities, to terminate the contract and seek appropriate remedies. Following a breach, the injured party, in this case the police authority, is entitled to seek appropriate remedies. The primary remedy in this situation would be the award of damages. Damages are aimed to put the injured party in the position they would have been in had the contract been properly performed. The police authorities would be entitled to recover the full amount agreed upon for their services. Additionally, under the Competition and Consumer Act, Schedule 2 Australian Consumer Law, particularly Section 18, which permits misleading or deceptive conduct, there could be an agreement that the honor refusal to pay constituted a deceptive conduct, thus allowing for broader remedies, including compensation under Section 236. Moreover, through rare in-service conduct, a remedy of specific performance, requiring the defaulting party to perform their contractual obligations, may be theoretically available. However, in practice, courts generally award damages for services contract breaches instead of ordering specific performance. It is also worth noting that under Section 5B of the Civil Liability Act, parties must take a reasonable care to prevent economic harm to others where it is possible, although this statute more directly addresses tortious liability. It supports the broader principle that obligations voluntarily undertaken must be honored, reinforcing the honor duty to pay for several provided. In conclusion, based on the application of Australian contract law, it is clear that a valid and enforceable contract was formed between the coal mine owner and the police authorities. All essential elements of contract formation, including offer, acceptance, consideration, intention to create legal or incantation, certainty, were clearly specified. The honest subsequent refusal to pay for the services after benefiting from the police protection during a period of critical operational risk amounts to a serious breach of contract under well-established common law principles, as well as statutory protections under the Competition and Consumer Act and the Civil Liability Act. The breach entitles the non-breaching party to pursue legal remedies. Consequently, the police authorities are not only morally but also legally entitled to seek damages to recover the agreed upon fees. They must also rely on statutory provisions to reinforce their claim and ensure that contractual obligations are upheld. The legal framework make it clear that agreements voluntary entering to must be honored, and that branches of such agreements attract enforceable consequences. Thank you for your attention.